Okay, we are live on YouTube.
Great. Welcome everybody to House Energy and Digital Infrastructure. It's Wednesday, May 21. And we are joined today with Barry, it's Tabin, right?
Perfect.
With Barry Tabin, Legislative Director of State and Federal Affairs at the National Conference of State Legislatures. And we have been following from afar a proposed federal ban on states' ability to enact legislation pertaining to artificial intelligence. Needless to say, great concern, I'm sure, state legislatures all around the country. I just heard a promising rumor out in the hallway, but Barry, we had asked you to come in today and join us and tell us everything you know about the proposed ban. And even if it's on or off right now, I know I'd like to learn as much as we can about it in case it, returns or persists. So we'll just quickly introduce ourselves. I'm Representative Kathleen James from the Bennington 4 District.
Chris Morrow, Wyndham, Windsor, Bennington.
Michael Southworth, Caledonia 2.
Christopher Howland, Rutland 4.
Garrett Horry, Washington 2.
Graham Kleffner, Chittenden 13, Burlington.
And Scott Campbell, representative from St. Johnsbury.
Great. Barry, for the record, I guess we can turn it over to you. We do have your testimony. Thank you.
Terrific. Thank you so much. So what I'll do is I can go ahead and read the prepared statement, but I am very flexible. So if you want to stop me in the middle, if you want to wait to ask questions, however you would like to roll forward, I'm very happy with that. So I'll go ahead and begin with the, does that sound okay?
Yeah,
Madam
we'd
Chair?
love to go through, regardless of any late breaking developments, we'd love to go through your testimony, and we'll stop and maybe we'll let you, well, we'll just see if people have questions as we go along.
Okay, great. Wonderful. Okay. Good morning, Chairwoman James, Vice Chair Campbell, Ranking Member Sibilia, and members of the committee. My name is Barry Tabin, and like the chair said, I'm a legislative director with the National Conference of State Legislatures. I'm located in Washington, D.C., and I lead our technology and financial services advocacy in D.C. before Congress, federal agencies, and the administration. And as many of you know, NCSL is a bipartisan organization representing the legislatures of our nation's states, territories, commonwealths, and Washington, D.C. Now, based on a resolution which was unanimously approved at our legislative summit last August, the organization strongly opposes the 10-year moratorium on the enactment and enforcement of state artificial intelligence legislation and regulation currently included in the U.S. House of Representatives Budget Reconciliation Bill. And as you also might know, NCSL sent a letter to the House Energy and Commerce Committee to that effect, and we plan to send a letter to the full House later this week. Now, going into the provision a little bit, it's section 43201C, in case you're looking at this ginormous bill, of the House Budget Reconciliation Bill, and it specifically states, no state or political subdivision thereof may enforce any law or regulation regulating artificial intelligence models, artificial intelligence systems, or automated decision systems during the 10-year period beginning on the date of enactment of this act being the reconciliation bill. And I also just want to point out the most up-to-date version also added some additional qualifying language. So when it talks about artificial intelligence models, artificial intelligence systems, and automated decision systems, it now says entered into interstate commerce. And we can talk a little bit more about what that means later. Now, in our reading, regardless of the new language, and the reading of many other organizations concerned about this provision, we believe such a moratorium would foreclose the state's ability to enact and enforce a host of significant AI laws for the next 10 years. This would be true of laws passed in red states, in blue states, in purple states, and true for laws that have been in effect for many years. The scope of such a moratorium for states is potentially enormous and means that state laws aimed at things like mitigating algorithmic bias, requiring transparency or disclosures, establishing consumer protections for AI-driven services, preventing exploitation, prohibiting deepfakes, curtailing scams and frauds perpetrated against older Vermonters and kids, protecting communities from noise and high energy costs associated with data centers, and quite possibly protecting children from harms associated with social media, and that's just to name a few, would not be enforceable unless they fall under a narrow set of exceptions outlined in the bill. Now, as I mentioned earlier, NCSL's membership adopted a policy resolution on AI last August, exactly because the technology is so essential to enhancing or infringing on the rights and abilities of all Americans. In the resolution, NCSL urges Congress and federal agencies to consult with states as they debate and develop AI legislation and regulations, paying particular attention to how any federal law or regulation will impact state laws governing AI. NCSL maintains that federal laws and regulations in the AI space should set a strong baseline of rights and safety protections and support states' ability to adopt additional protections in their own laws to keep pace with and respond to rapid AI technological advances. States have consistently demonstrated a greater ability to respond quickly and effectively to emerging technology than Congress or federal agencies, a reality that is going to remain true for the foreseeable future. A rigid, all-encompassing preemption of state authority, like what we're seeing in this bill, would hinder innovation in public policy, limit consumer protection, and prevent states from addressing rapidly evolving AI risks in real time. Congress must avoid adopting a one-size-fits-all approach that restricts state leadership and undermines their essential role in safeguarding residents and businesses. And I will say that that's what we said in our letter, and that's what we will continue to advance, I think, in the forthcoming letters and as this reconciliation bill moves through Congress. Now, the bill does provide some exceptions to the moratorium, and we'll talk about those now. So states may continue to enact and enforce laws designed to facilitate the deployment of AI or remove legal impediments to its use. So specifically, the bill permits laws whose primary purpose and effect is to streamline licensing, permitting, zoning, or procurement processes in ways that support AI adoption. Additionally, the moratorium does not apply to generally applicable technology-neutral laws that treat AI systems the same as non-AI systems performing similar functions. And states are also allowed to impose reasonable cost-based fees or bonds on AI systems, provided these financial requirements are applied uniformly to comparable technologies. Now, recently added to the bill is an important provision. The bill exempts state laws from the moratorium that impose criminal penalties, such as those targeting AI-generated child sexual abuse material, called CSAM. This means that state statutes criminalizing the creation or distribution of AI-generated CSAM would remain enforceable under the moratorium. Now I'll move on and we'll talk a little bit about process. So the proposed 10-year moratorium included in the House budget reconciliation package faces mounting opposition and procedural challenges as it moves through Congress. So the measure does have support from some GOP lawmakers and, of course, major tech firms advocating for a uniform federal framework. But it also has drawn bipartisan concern and criticism from a broad coalition of stakeholders. So NCSL, 40 bipartisan state attorneys general, the Council of State Governments, the National Association of State Chief Information Officers, the North American Securities Administrators Association, and numerous state legislators have urged congressional leaders to remove the provision, citing concerns over state sovereignty and regulatory overreach. In addition, cybersecurity experts warn that preempting state authority could leave critical gaps in oversight, particularly given the absence of comprehensive federal AI legislation, and consumer advocacy and civil rights organizations argue the moratorium would effectively shield companies from accountability by nullifying existing state laws aimed at addressing algorithmic bias, transparency, and misinformation. Now, in the Senate, the moratorium faces additional scrutiny under what's called the Byrd Rule. So, under this rule, senators can challenge and potentially remove from the bill any provision that does not have a direct budgetary impact or where the budgetary effects are merely incidental to the policy change. And given that the AI moratorium primarily serves as a regulatory measure, that would be to preempt states rather than a fiscal one, it could be found ineligible for inclusion in a reconciliation package. And Senators John Cornyn from Texas and Bernie Moreno from Ohio have both raised concerns about using the reconciliation process to advance significant policy changes, warning that it could erode legislative norms. And given the breadth of the opposition and the strict Senate rules, the moratorium's chances of surviving reconciliation remain uncertain. Now, despite concern and outright opposition to the proposed moratorium, as of now, we've heard of no state or organization that has formally initiated a challenge against the proposed moratorium. Legal experts have noted that such a federal moratorium could be subject to judicial review, particularly if it's perceived to infringe on states' rights or overlap federal authority. I suspect we'll have to wait and see, and we can discuss more about litigation during the questions and answers. So those are my official written statements. Thank you again for inviting me to join you today. And I'm here as long as you need me and glad to answer any questions or concerns you might have.
Representative Campbell.
Oh, gee, thanks. Well, I guess the first question is there any movement in Congress towards comprehensive AI regulation?
There is not. As far as we understand, there is not. And we have been quite up and about on Capitol Hill discussing this. It's interesting because we were advised by some leaders that there was not a lot of traction in the comprehensive AI area, that in fact, senators and representatives were looking at more piecemeal movement in AI. And in fact, there have been lots of individual bills. I was just checking one that discusses education, funding education to, educate the public about what AI means. There's a lot of misinformation and, misunderstanding. There is legislation dealing with more funding for research and elevating research and sharing that around. But there is no comprehensive AI bill at this time.
All right, well.
Yes, exactly.
Forget it then. I mean, Congress, if you're not going to do it, then,
Exactly, exactly.
That also leads to the question of, there was a mention about comparable technologies. Are there comparable technologies? What would be comparable to AI?
I have no idea. And those are all very, very good questions. And I think it's interesting because the chair asked me also to discuss litigation. And this is a concern that I have because there are so many things I think, or we at NCSL think are unclear in the bill. A state may go ahead and try to legislate in this space, only find that they're subject to very deep pocket lawsuits by industry. Yeah. So again, with the unclarity, what does it mean for something to be comparable? What does it mean for something to be in interstate commerce? There's a lot of unclarity and uncertainty, and I think that can be very problematic.
Yeah. Okay. Well, and then the other question about legislating, you mentioned there's, of no legislation challenging the possible moratorium, but it seems like how could you challenge something that is not in effect yet?
Exactly. That's exactly the point, right? We'd have to see where it goes. I mean, yeah. I'm trying to be hopeful that because of the Byrd Rule, this will ultimately be stripped from the Senate bill. But there are procedural ways around that. We'll keep our fingers crossed. But you're right. It has to be enacted before somebody's going to bring a case against it.
Great. So thank you very much for this overview.
Of course.
Barry, we had heard, I literally just heard minutes ago in the hallway that it's out now. Did you hear that latest rumor from minutes ago?
Well, I didn't hear that minutes ago rumor because I was trying to click into your Zoom link. This is what I do. I did not want to be the late speaker, but let me say, this is what I do know. Most assuredly, at 10:15, so now as we speak, there is a House subcommittee hearing before the Subcommittee on Commerce, Manufacturing, and Trade. And that whole hearing is largely about this moratorium. So I know that they're having a discussion about it now. Now, I haven't seen anybody send me any emails while I'm sitting here, any of my colleagues. And I will say, and I think this is noteworthy, it would be wonderful for it to be stripped out of this bill for a million reasons, least of which is that we believe at NCSL, in our view, that it's a violation of the bird rule. But I will say that I did read this morning and have heard much scuttlebutt that this is something that is gaining traction in Congress regardless, right? So even if it's not part of the reconciliation bill, there is definitely going to be an effort to preempt states in this arena. Now, I think outside of reconciliation, this will have a much more difficult time getting across the finish line. The vote threshold is much different. And also, to Representative Campbell's point, there is no comprehensive federal bill. So that I think will add some conversation to the question, because, even if you are in some way for preempting states' rights, you potentially would need something to point to at the federal level, and you don't have anything like that right now.
Can you remind me the timeline for the reconciliation bill? I can't remember.
Yes, absolutely. So right now, the bill is moving through the House to begin. It has to originate in the House of Representatives. The Rules Committee is working on a rule, that will govern amendments and the time of the debate. And I believe that is something they're going to vote on shortly. And I believe the goal is to have a full House vote on the reconciliation bill before Memorial Day, which is coming at the end of next weekend? No, at the end of this weekend.
This weekend.
Yeah, the end of this week, right. So I think the time in the House is sort of chop. The Rules Committee will be voting. They'll move it to the floor. There are other issues that are being negotiated as well that they're working on. It would be wonderful if this was stripped out. I was not confident that this provision would be eliminated on the House side. I was more hopeful that we would see some concern on the Senate side. A senator of either party can make a motion, a point of order to remove the provision because of the bird rule. And it takes quite a lot of votes. I think 60 senators have to agree to waive the bird rule. And I don't think you would get that with this Senate. So that's sort of how we're moving along. And one thing I wanted to clarify, and I was doing a little research before I came on with all of you. So once the bill moves out of the House, the Senate is not necessarily taking up the House bill. They could take a little provision here, a bit of a provision there, but basically also start their own process. And a colleague sent me some information before I clicked on, knowing I was testifying, that said that reconciliation can take anywhere between 50 days and like 350 days. That's sort of a historic overview, with the average being 150 days. So we have a bit of a haul, I think, until we finish the process.
And you mentioned earlier something that was alarming to me, which is that this isn't necessarily just a one-off. This could be a recurring theme in Congress outside of or beyond or outliving this particular reconciliation bill.
It will be. I believe that it will be. I think that the tech industry is leaning very, very hard on members of Congress of both parties to adapt some sort of moratorium on state activities. And, they're powerful groups. Some of their rhetoric is resonating. And we on the state side are trying to elevate the really good work that states are doing. The idea that they are working across party lines, that they're working in public-private partnerships, that this is not a bipartisan issue in the states. That they're working across states even, coalescing together to find out what different states are doing and how they're moving forward to make things simpler for industry. And just also reminding folks that we do, in fact, have a 10th Amendment, and that states and state partners are not the bad guys. And that's, I think, what's a bit upsetting, is they're being perceived as the bad guys, as folks who don't care or want to see this technology evolve. And my experience from working with all of you in all the states around the country is that could not be farther from the truth. So, we're trying to elevate that before members of Congress.
Representative Sibilia?
Yeah. So I would just note that we have seen this we saw this with net neutrality here.
Yep.
And even with broadband build out. And
Yep.
in Vermont, I believe we won on the basis with California and others that in terms of being able to use our police power. I think, has Maria given us that kind of walk through our ability to protect our citizens? So actions that we take to for consumer protection and using our police powers have been upheld. The net neutrality was a big,
Mm-hmm.
so
That's an excellent point. I wrote it down. I'm going to think more about it. I think it's an excellent point. And I think, again, that goes to sort of the worry that I was expressing earlier, which is if something like this got across the finish line, where would states determine that they want to legislate? And what would that open them up to, right? So if Vermont decided you wanted to go forth and say, under our police powers, we have the ability to protect our consumers, our constituents, we're going to regulate in a particular area. Would industry come in and say, well, that's lovely, Vermont, but you're protected. And if you pass this, we're going to bring you to court. Like this is some of the concern that I have when you have, some uncertainty, which doesn't preclude states from doing it. They're very brave. They do things all the time that might subject them to litigation because they feel that it's in the best interest of their constituents. But that's something that goes through my mind and NCSL's mind. But I think that's an excellent point about the police powers. And I wrote it down to note.
our legislative our legislative council has been through a few of these and did move forward with net neutrality provisions. It was very interesting. That worked out over time, but
yeah,
just protecting our citizens.
For state though, right? That's where it's effect right now?
That was where it started. And then we should have Maria come in and walk us through.
Yeah, we
what
should.
happened with that.
Yeah,
We
absolutely.
talked about net neutrality some, but
And not going too much in the weeds, but I have seen preemption legislation, and we had a little bit of this with a privacy bill, which is not unrelated to AI last year in Congress, where there was an effort to preempt state privacy laws, but it actually then included a number of exemptions that carved out state legislation adopted for specific purposes, like consumer protection, like HIPAA, things that are traditionally within the authority of state government. So there, listen, preemption is not something we would, embrace regardless, but certainly something could be much more narrowly drawn to protect police powers, to protect consumer protection, to protect HIPAA. This is a quite significant and expansive moratorium with no federal replacements, no comprehensive federal replacements. And that's, I think, important to note.
because when, and I'm not an attorney, but federal law in general preempts state law if there's a federal law, right? I mean,
if there's federal activity in the space, that's exactly right. That's right.
so one thing I want to understand then is, so if there's federal activity in the space, that would be some sort of comprehensive, or can federal activity in the space be defined as this moratorium?
Well, I think that the moratorium, it doesn't really say anything. It doesn't give guardrails. It doesn't give parameters. It doesn't give instructions. All it says is you are preempted, states. So I would think, it's a little bit like the Wild West if this were to go forward, because there's no, for consumers, for the public, for industry, there's nothing out there then at the federal level, no guardrails, all of the good laws that states have enforced, have enacted, and are now enforcing would eventually, even those that have been in effect for many, many years, would be preempted. So I'm not really sure at this point what would take their place. There doesn't seem to be anything unless Congress somehow believes they're going to quickly act to address this void, which, you know, does not always happen that quickly. I mean, they have to finish the reconciliation bill. That's going to take a while. There are other priorities. So there would be quite a void.
Do we have additional questions for Barry? Okay.
Okay, folks.
Thank you. Thanks for joining us and for your written testimony and for your expertise. And just, I know there's a lot of you, but the NCSL has just been an incredible resource to our committee this year. And I'm really grateful.
My pleasure. And I will invite any one of you together or individually. You're always able to reach out to me about anything. Doesn't only have to be about this. I'll get you to the correct person.
Great.
And Madam Chair, I will also, when I hang up with you, do some due diligence. And if I find that this has been stripped, you'll hear from me momentarily in an email.
Great. Well, that was literally as I was walking into committee. So who knows? But
Okay, wonderful.
thank you so much for the time you spent. Really, whether it's in or out right now, this is really valuable.
Excellent.
That's really
Terrific.
correct. So thank you
you.
so
All right.
much. And
Have a lovely day, everybody. And thank you
yeah.
for having me.
you too.
Thank
Thank
you.
you.
Bye-bye. Bye.